On July 16, 2024, US Citizenship and Immigration Services, USCIS, unveiled new policy guidance addressing non-compliance and sanctions under the EB-5 program. The updated policies in Volume 6 of the USCIS Policy Manual incorporate statutory reforms included in the EB-5 Reform and Integrity Act of 2022, RIA, which took effect on March 15, 2022. The policy alert explains that the reforms add new authority for USCIS to sanction regional centers at various levels for non-compliance with statutory requirements, such as paying the EB-5 Integrity Fund fee. Unsurprisingly, this new update has raised many questions, and many investors may wonder what it means for them. In this video, we address the four most crucial questions regarding the new guidelines. USCIS's new guidelines further clarify how these protections work and demonstrate USCIS's intention to protect innocent investors to the fullest extent possible. Thus, these new integrity measures, the potential penalties, and good faith investor protections should make investors feel more comfortable and secure about investing in the EB-5 Regional Center program than ever before. If the USCIS terminates a regional center or debars an NCE or JCE as the immigration process for good faith investors protected by the RIA? Generally speaking, yes. If the investor has met the EB-5 eligibility requirements by investing the requisite funds, sustaining that investment through the required period, which differs for pre- and post-RIA investors, and creating the necessary jobs. According to the USCIS, post-RIA investors may continue to be eligible if their capital remains invested for at least 2 years after being placed at risk. The investment must have satisfied the job creation requirement before the regional center's termination or debarment. In such cases, USCIS officers may determine that the investor remains eligible even without reassociating with another approved regional center or investing in an NCE. How will investors learn that their regional center, NCE or JCE has been terminated or debarred? What steps must investors take to avail themselves of the good faith investor protections? USCIS will provide each investor with written notice, and each investor will have 180 days to respond. The steps investors must take will depend on the facts and circumstances of their particular situation and whether the investor is pre- or post-RIA. If the investor has already met all eligibility requirements, the only required action might be to notify USCIS that the investor remains eligible despite the termination or debarment. However, in some instances, the investors must amend their petitions. The USCIS guidelines address situations where investors may face significant challenges, stating that if their regional center is terminated or their NCE or JCE is debarred and their capital investment project has failed or will only create less than the requisite number of jobs, they generally will not remain eligible. However, the guidelines offer a potential solution, noting that in such cases, investors may use the protections under to amend their petition to retain eligibility. This applies to both pre- and post-RIA investors, allowing them to maintain their eligibility despite the difficulties they may encounter with their regional center, NCE or JCE. According to the USCIS guidelines, even if an investor's regional center is terminated and their project has failed, they may still have options to retain their eligibility. The guidelines state that in such cases, investors may amend their petition to retain eligibility through their NCE reassociating with an approved regional center, or by making a qualifying investment in another NCE. This allows investors to ensure they continue to meet the necessary requirements, such as job creation, despite the setbacks they may have faced with their original regional center and project. Does the RIA provide good faith investors protections in circumstances where their project has failed financially or to create sufficient jobs, but the regional center and NCE remain in good standing? In short, no. The USCIS guidelines clarify that an immigrant investor can only retain eligibility under Section 203 if we terminate their regional center or debar their NCE or JCE. This means that project failure alone does not provide a basis for retaining eligibility under this specific section of the INA. If an investor wishes to reassociate their NCE with another regional center or make a qualifying investment in a new NCE due to project failure, and this failure is separate from the termination or debarment of their regional center or entities, they must follow a different path. In such cases, the guidelines state that investors must file a new petition for classification based on post-RIA eligibility requirements. The good faith investor provisions were not intended to serve as a catch-all for investors. A key eligibility requirement is that an investor's capital is at risk. The RIA good faith protections are not designed to eliminate investment risk, but rather to protect investors from bad or non-compliant EB-5 actors. They do not protect investors from bad choices. Therefore, it remains absolutely critical for investors to conduct thorough due diligence and to select experienced regional centers with stellar track records, including excellent project selection, project management, and project repayments. Well, we have reached the end of the video. We hope that the information has been useful to you, and if you want more personalized legal advice, we leave you the link here. Don't forget to subscribe to our channel, leave us a comment, and like this video. See you soon with more news.